To the casual observer, the case against Nick Reiner appears locked in a vault of forensic certainty. Surveillance footage tracks his movements, a Santa Monica hotel room reveals a shower stained in crimson, and a high-profile argument at Conan O'Brien's residence provides a motive as clear as a Hollywood script. The public consensus is simple, a tragic, open and shut betrayal, but in the architecture of the American legal system, reality is rarely a straight line. With the entry of Alan Jackson, the legal architects behind some of the most complex, high-profile acquittals, the slam dunk is revealed to be a mere mirage. Jackson doesn't play the game of facts, he plays the game of systems. To understand how an apparent monster becomes a victim of circumstance, we have to look deeper into the legal machinery designed to find the cracks.
In the high-stakes theater of the Los Angeles Superior Court, the insanity defense is not a plea for sympathy, it is a clinical deconstruction of the human machine. This is the M'Naughton rule, a legal architecture dating back to 1843 that demands a binary answer to a spectrum of cognitive chaos. To win, Alan Jackson must prove that at the precise moment the blade met flesh, Nick Reiner suffered from a mental disease so profound that he was incapable of knowing the nature of his act, or, more crucially, that the act was morally wrong. It is the ultimate legal anomaly, a trial where the facts of the killing are conceded, but the intent is treated as a ghost in the machine. The defense's leverage lies in a systemic reality, Nick Reiner's long-documented battle with schizophrenia. In a city where celebrity facades often hide crumbling psychological foundations, Reiner's history is not just background noise, it is the fundamental catalyst for this defense. Imagine a mind where the internal wiring has sparked and fused. If the defense can present a narrative where Reiner wasn't killing his parents, but rather defending himself against what his fractured psyche perceived as demons or alien entities, the moral compass of the crime spins wildly. This isn't just about being crazy, it's about a total cognitive disconnection from the collective reality.
However, the paradox lies in the defendant's behavior after the event. The prosecution will point to the architecture of guilt, the hotel check-in, the washing of blood, the calculated silence. A person who knows they need to hide, they will argue, is a person who understands that their actions were wrong. This is where the trial becomes a battle of experts. Jackson will likely utilize the bifurcated trial system unique to California, a two-phase ordeal where the jury first decides if he did it, and then in a second grueling phase, whether he was legally sane. The difficulty of this path cannot be overstated. Statistically, the insanity defense is the Hail Mary of the legal world, succeeding in less than 1% of cases. It requires the jury to perform a feat of extreme empathy, to step inside a mind that has completely abdicated reason. Yet, with a history of documented clinical episodes and the sheer nonsensical brutality of the crime, killing the very people who were his primary support system, the defense argues that the horror of the act itself is the strongest evidence of a mind in total collapse. But what if the source of this collapse wasn't just internal biology, but an external, invisible poison? If the architecture of madness is a failure of the internal machining, then involuntary intoxication is the theory of the poisoned chalice. In the shadow of the Brentwood tragedy lies a pivotal scene, a Christmas party at the home of late-night icon Conan O'Brien. Witnesses describe a Nick Reiner who was freaking everyone out, a man adrift in a sea of celebrities asking erotic questions and spiraling into a confrontation with his father. To the prosecution, this is the preamble to murder. To the defense, this is the moment the invisible catalyst was introduced. The strategy here is precise and high risk. CalCrim 3427, the California jury instruction for involuntary intoxication. For this defense to take hold, the narrative must pivot from addict in a relapse to victim of a systemic anomaly. Nick Reiner's history with heroin and cocaine is no secret. He co-wrote a film about it. But a voluntary relapse is a legal dead end. Involuntary intoxication, however, is a complete defense, a get-out-of-jail-free card in the most literal sense. It posits that Reiner did not choose his state of mind. It was thrust upon him through fraud, trickery, or a lethal lack of knowledge. Imagine the defense's reconstruction of that night. They will search for a gap in the timeline, a moment where a drink was left unattended or a substance was mislabeled. If they can prove that Nick, believing he was sober or perhaps just consuming a standard alcoholic beverage, was unwittingly dosed with a hallucinogen like PCP or a synthetic stimulant, the entire moral architecture of the crime collapses. Under California law, if you were drugged without your consent to the point of unconsciousness, meaning you were unaware of your actions, you cannot be found guilty of any crime.
You are, in the eyes of the law, a biological puppet. But the paradox lies in the burden of proof. The defense must navigate the treacherous waters of Reiner's own history. The prosecution will argue that any intoxication was a choice, a return to the familiar patterns of a troubled past. They will portray the behavior at the party not as the result of a spiked drink, but as the friction of a long-simmering resentment boiling over. The invisible catalyst defense requires a forensic miracle, a toxicology report, or a witness testimony that can distinguish between a voluntary high and an accidental poisoning. Without that proof, the defense faces a systemic hegemony, the legal belief that we are responsible for the chemicals we put into our bodies. Yet, in a world of high society parties and designer substances, the line between a choice and a trap is razor thin. If Alan Jackson can plant the seed of doubt that Nick Reiner was a passenger in a body fueled by a drug he never asked for, the charge of first-degree murder begins to dissolve. In the cold, sterile logic of California's penal code, not every act that results in the end of a life is weighted equally. The law draws a razor-sharp line between the cold-blooded and the hot-blooded. This is the spectrum of intent, a legal architecture where the difference between spending the rest of one's life behind bars and having a chance at eventual parole hinges on a single ephemeral concept: premeditation. For the prosecution, Nick Reiner's walk from the party to the master bedroom was a calculated march toward a predetermined conclusion. For Alan Jackson, that same walk was a blur of cognitive static, a spontaneous explosion of a fractured mind that lacked the cool reflection required for first-degree murder. To understand this defense, one must dismantle the mirage of the planned hit. In many jurisdictions, premeditation is often misunderstood as a long-term plot. However, under the systemic rules of California law, it can happen in the blink of an eye. Yet the defense's strategy relies on the paradox of the disturbed mind. If Nick Reiner was in the throes of a schizophrenic episode or a drug-induced fog, his ability to deliberate, to weigh the consequences of his actions with a clear head, was fundamentally compromised. Jackson isn't arguing that Reiner didn't do it. He is arguing that Reiner didn't plan it. He is looking to downgrade the charge to second-degree murder, shifting the sentence from a mandatory life without parole to a potential 15 to life. This is where the narrative of Being Charlie, the 2016 film Nick co-wrote with his father, becomes a haunting piece of evidence. The film depicted a combative relationship between a son lost in the haze of substances and a distant, cold father. The defense will argue that the events of that night were not a new plan, but a tragic final crescendo of a decades-long systemic failure in their personal architecture. The argument at the party wasn't the motive, it was the catalyst for a spontaneous mental break. In the eyes of the law, a sudden impulse, even a violent one, is not the same as a calculated execution. The challenge lies in the weapon of choice. The prosecution will point to the knife, arguing that the act of retrieving a blade and entering a bedroom constitutes a decision. But Jackson will counter with the anomaly of spontaneity. He will paint a picture of a house filled with tension, where a knife is not a tool of an assassin, but an object grabbed in a moment of utter psychological collapse. If the jury believes that Nick snapped rather than selected, the hegemony of the prosecution's first-degree case begins to crumble. By attacking the intent, the defense attempts to find a middle ground in the darkness, a way to acknowledge the tragedy without sealing the door to a cage forever. In the legal arena, self-defense is the ultimate reversal, a transformative narrative that reframes a killer as a survivor. But in the Reiner case, this strategy encounters a jarring physical reality, the paradox of the imminent threat. How does a 32-year-old man in his physical prime argue that he was forced to use lethal, multiple sharp force measures against a 78-year-old father and a 70-year-old mother? Under California law, the defense of perfect self-defense requires a reasonable belief that one is in imminent danger of being killed or suffering great bodily injury. It is a high-bar architectural requirement that demands an immediate, proportional response to a life-threatening catalyst. However, Alan Jackson's most potent weapon might not be perfect at all. Enter the concept of imperfect self-defense. This is a legal anomaly where a defendant genuinely but unreasonably believes they're about to be offed. If Nick Reiner, fueled by a schizophrenic delusion or a drug-induced paranoia, truly perceived his parents as an existential threat, the law may downgrade murder to voluntary manslaughter. This This isn't about the objective truth of the parents' actions, it's about the subjective, fractured truth within Nick's mind. In this heat of passion framework, the courtroom becomes a study of systemic terror. The defense will argue that the argument at the party wasn't just a spat, it was the trigger for a psychological fight or flight response that never shut off.
The sensory details of the crime scene, however, present a formidable facade for the defense to dismantle. The prosecution will emphasize the location, the master bedroom. In the geography of a home, the bedroom is the ultimate sanctuary. To enter that space with a blade suggests an invader rather than a defender. Furthermore, the sheer number of wounds, described as multiple sharp force injuries, suggests a level of rage that exceeds the proportionality required for self-defense. To a jury, this looks less like a shield and more like an execution. To counter this, the defense must lean into the thick description of the Reiner family dynamic. They may search for any history of domestic volatility, any archival evidence that the relationship was a tinderbox of mutual aggression. They will attempt to paint the renowned director and celebrated producer not as victims in a vacuum, but as participants in a deeply strained architecture of mutual resentment. If Jackson can convince even one juror that Nick Reiner struck out because he felt, however wrongly, cornered in his own home, the impenetrable murder charge begins to bleed out. When the what and the who of a crime seem undeniable, the defense turns its gaze toward the how. This is the cracked foundation, a direct assault on the state's investigative architecture. In the high-stakes world of the LAPD, the pressure to solve a celebrity double homicide creates a systemic haste that can lead to catastrophic procedural errors. Alan Jackson's strategy here isn't about proving Nick Reiner's innocence, it is about proving the government's incompetence. By invoking the Fourth Amendment, the defense seeks to suppress the very evidence that makes the case appear like a slam dunk. The paradox of forensic certainty lies in the chain of custody. Think of the blood-stained mattress in the Santa Monica Hotel, or the digital footprint left by Nick's own credit card. If the defense can prove that the entry into that hotel room was performed without a valid warrant, or that the search exceeded the scope of the legal authorization, that evidence becomes fruit of the poisonous tree. It is a legal mirage. The blood is real, the DNA is a match, but because the system's rules were violated, the jury is never allowed to see it. Jackson will scrutinize every minute of the LAPD's response, from the initial discovery by Romy Reiner to the arrest in Exposition Park, looking for the systemic anomaly that renders the evidence inadmissible. Furthermore, the defense will attack the forensic integrity of the crime scene itself. In a Brentwood mansion with multiple occupants and frequent staff, the architecture of the crime scene is inherently noisy. Was the DNA collection performed with clinical precision, or was there cross-contamination? Was the multiple sharp force analysis conducted by a coroner with a history of bias or error? By putting the LAPD on trial, the defense pivots the narrative from Nick Reiner's actions to the state's rush to judgment. They will point to the lack of a recovered murder weapon, a fundamental gap in the prosecution's narrative, as evidence of a sloppy, incomplete investigation. This is a battle of hegemony versus rights. The prosecution relies on the overwhelming weight of their evidence, while the defense relies on the sanctity of the process. If Jackson can expose even a single instance where Nick's constitutional rights were bypassed in the name of a quick arrest, he can dismantle the prosecution's momentum. In the world of elite defense, you don't always need to prove the defendant is a saint. You just need to prove that the police are human and that their humanity led to a flawed, unconstitutional, and ultimately unreliable investigation. The case of Nick Reiner is more than a tabloid headline. It is a profound collision between the fragility of the human mind and the rigid gears of the American legal machine. We have dissected the architecture of madness, the invisible catalyst, and the cracked foundation of the state's evidence. Each of these 5 defenses represents a different way of asking the same haunting question. At what point does a human being cease to be the author of their own actions? In the pursuit of justice, we often crave a binary reality, a clear-cut choice between a monster and a victim. But the Reiner tragedy exists in the gray space of the systemic paradox.
If a man's biology betrays him, or if a chemical poison rewires his intent, is the resulting violence a crime or a symptom? As Alan Jackson prepares to lead the jury through this labyrinth of perfect and imperfect defenses, the trial will not just be about a double homicide in Brentwood, it will be a trial of our collective understanding of responsibility in an age of clinical and chemical chaos.
The evidence is physical, but the truth is metaphysical. The cameras captured the movement, and the lab captured the DNA. But no forensic tool can ever truly capture the why hidden behind the eyes of a man lost in a schizophrenic fog. As this legal saga unfolds, we are left to wonder, in a world where the mind can become its own worst enemy, can a courtroom ever truly find the truth, or are we simply settling for the most convincing narrative? Does the law exist to punish the act or to understand the soul? And what happens to a society when it can no longer tell the difference?